One.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon, lawyers. Before we call the case, just a brief reminder that we don't anticipate any technology-related problems, but if something should happen, everybody just take a deep breath and pause, and nobody panic, and we'll work through it. Mr. Hibner, call the case, please.
State of Tennessee, ex rel. Herbert H. Slatery et al. Versus Necessary Oil Company et al.
We'll hear from the appellant.
Your Honor, Ken Hale from the Bristol Bar here, representing Necessary Oil Company and Realm Properties, LLC. Interesting little case before you, fairly simple in terms of facts and the layout of it. My client, Necessary Oil Company, operates an oil recycling facility here in Bristol. Realm Properties actually owns the real estate on which it is located. The facts that are before you stem from an oil spill into a nearby creek. As is typically, it was reported in Tennessee Department of Environmental Conservation, descended on the facility, began their investigation, and in terms of doing so, as is normally the case, poked and prodded and found other things that they liked and wanted to be done. Necessary began working with its engineers in an effort to accommodate those things. Numerous reports were submitted, some were rejected by the state, some were accepted. And at some point, TDEC decides that Necessary is moving fast enough and issues a commissioner's order assessing penalties and penalties going forward, and also discusses things that they need done. So we move forward at that point in time. The order assesses an economic, or finds that there's an economic benefit of about $700, assesses, and I say quote, damages of roughly $5,400, which equate to the state's out-of-pocket costs, assess a total penalty, and I'm talking rough numbers, of roughly $200,000, an upfront civil penalty of roughly $40,000, excuse me, and a staggered series of penalties going forward. The problem that faces Necessary at this point is they simply they continued to work with the state in an effort to meet their expectations, but did not file an appeal to the commissioner's order. At some point down the road, the state of Tennessee filed this proceeding in Nashville Chancery Court to enforce the administrative order. A motion for summary judgment was filed. Necessary and Realm responded to that. And again, the state makes a considerable advancement argument that we did not dispute the facts that are before the motion for summary judgment. The actual facts themselves are not really in dispute. The order was issued. Necessary and Realm did not respond. There are certain penalties that were assessed. Penalties haven't been paid, but here we are in an effort to collect those penalties. So the question becomes, is the administrative order subject to being challenged on its face for being facially void? If you look at the system that is set up for TDEC to assess civil penalties, they're very much similar to punitive damages as those are viewed by the court systems. They're deterrent. And if you look at the procedure for assessing punitive damages and or through the state court, through the state statute, and through the U.S. Supreme Court, those are not favored in the numbers as have been assessed here in with this particular commissioner's order. They're excessive. They're many times the multiplier allowed by both the state of Tennessee and the U.S. Supreme Court. And, you know, we think that they're egregious and basically unconstitutional. The The question is can this order be challenged at this point in this proceeding? And, Ragsdale says you can challenge an order at any time if it's a constitutional challenge. And the question is the order void ab initio? And what's happened here is the commissioner's order basically says you've been bad. It assesses a penalty, it assesses civil damages, and has this $40,000 penalty. But the issue is it did not follow the statutory analysis set forth in 69-3-115A3. And in there are several factors that.
Counsel,
Yes.
2 questions.
Yes.
Could you tell me when an appeal of this or challenge to this penalty was made? And could you tell me the initial challenge, where was that filed at?
The initial challenge was in the Chancery Court.
When? After?
It was after the order was issued, 30 days lapsed. There was no appeal filed to the administrative order. The state began an enforcement proceeding to collect the monies, and that's when the challenge was raised.
And how long after the actual assessment was that?
I'm going to ballpark it, Your Honor. I'm going to say 14 to 18 months.
Okay, thank you.
So we're downstream at some point. And again, this is a challenge to the order as it is written. So the question becomes is can that be done? The order facially does not address any of the factors required by the code. So the question at that point becomes, so the commissioner puts together an order, sends out penalties, assesses, punitive damages in essence, civil penalties, but they don't put into that order the basis for how they determine those penalties are calculated. So the only way that an aggrieved party can look at the order and figure out what's happened and what's been done is if they file an appeal. So the question comes is why does the state get to escape giving a rational basis for the assessment of substantial, huge penalties? And so if you want to know what we've done to you, you get to file an appeal. So, Your Honors, what I think is that because they've avoided the factors that are required to be assessed and not included those in the order, the order itself, the underlying administrative order, becomes facially subject to being challenged. So that's where we are. The state failed to articulate reasons for why it came up with these exorbitant penalties. There's no assessment that there was damage to the wildlife. There's no assessment that there were cleanup costs. There's nothing that go into filing an action for a substantial deterrent in terms of dollars and cents, other than the order says, or Judge Hobbs found that they were not moving as fast as they thought they should. So that's where we are. I think that when you're looking at hamstringing a defendant with huge sums of money, the state has to come forward and explain their reasoning and basis for the same. Their argument is, well, the statute doesn't require us to do that. We don't have to do that. If you want to know why we did that, you get to file an appeal. And then after you file the appeal, we'll tell you. And we think that that's a due process problem. They need to explain and tell why they're doing what they do. And because of that, this order is facially void ab initio. Thank you.
Thank you, counsel. We'll hear from the state, the appellate.
Good afternoon. May it please the court. Elizabeth Picarder for the state appellees. Tennessee law does not allow a direct challenge to an alleged void judgment or order if that challenge is time barred, which is the case here, because the appellants simply did not seek to avail themselves of administrative remedies that were clearly set out in the Water Act. And so the constitutional challenge that's before the court today is essentially moot. It may be worth a brief recap of the procedural history, since Judge McClarty did ask about timing. The commissioner's order and assessment, which is the subject of this dispute, was issued in the summer of 2019. On the face of that order, and this is in the record, obviously, it sets out that the upfront civil penalties and the upfront damages are due and payable within 30 days of service. Now, it also contains within that order a very clear notice of rights provision at the end. And I would encourage the court to review that notice of rights provision because it sets out the statutory mechanism for seeking administrative review. It's in the record, and the appellants don't dispute that they did not seek any administrative review within the 30-day time period. And so the next thing that happened was in 2020, the state initiated this legal action to enforce the administrative order. And in a timely manner, the appellants filed a written answer in the trial court. But in that written answer, they raised affirmative defenses, none of which raised any constitutional infirmities with respect to the commissioner's order or the penalty statute. It was not until 2021 that the state filed its motion for partial summary judgment. And at that time, when we were seeking to secure payment of the upfront penalties and damages, it was at that time that the appellants had their epiphany. Almost 2 years later. Now, realize that in their reply brief before the court, the appellants have attempted to somewhat reframe or recharacterize the nature of their constitutional challenge, at one point suggesting that perhaps the penalty statute itself is facially invalid. But in fact, if we parse carefully all of the arguments that the appellants made at the trial court level and in their opening brief before this court, it's clear that they have never been making a facial constitutional attack on the penalty statute. Quite the contrary, as my opposing counsel has just made clear, their arguments seem to be focused on deficiencies in the commissioner's order. They are arguing that the commissioner's order and assessment was improperly drawn because it did not provide a basis for the calculation of the upfront civil penalty and the upfront damages. In a sense, the appellants are almost defending the facial validity of the penalty statute because they go on to argue that the commissioner's order fails because it doesn't incorporate or cite appropriately the statutory factors set out in the penalty statute, which is 69-3-115A. They go on and say, well, the order didn't provide us with adequate notice because it doesn't describe those factors or cite those factors. It didn't provide sufficient rationalization or analysis. But all of those deficiencies go to the commissioner's order. They don't go to the penalty statute. And for these reasons, the appellants can't meet the rule announced in Richardson and later refined in Colonial Pipeline. Both of those cases make clear that administrative agencies may, in certain circumstances, hear and decide certain constitutional issues. In one very narrow area, they may not. That narrow area is that an administrative agency may not issue a declaratory ruling on the facial validity of a statute it administers. That's not what we have here. What we have here is an as-applied challenge. The appellants are suggesting that the commissioner's order did not properly apply the statute. They are not arguing that the statute itself on its face has any defects. And for these reasons, they simply can't meet the tests that would allow a trial court to reach down and decide this type of constitutional issue without allowing administrative review. In Colonial Pipeline, the court went a little further and provided a very detailed and nuanced discussion of the exhaustion doctrine as it applies to administrative agencies. And in doing that, it also shed some light on the policy considerations, the very legitimate policy considerations that undergird that exhaustion doctrine, including judicial economy, matters of institutional competence, allowing administrative agencies the opportunities to correct any errors, develop an adequate record, appeal. Problem here is that the Water Board never had this opportunity. The appellants simply never sought that administrative review. Why, we can't say. Maybe they thought the state would never seek to collect this money. But here we are. The other thing I would point out is that in all their arguments, the appellants have never suggested or maintained that they should be excused from the exhaustion doctrine because the Water Board doesn't or can't provide a fair and impartial review on these issues. They've never said that, nor have they argued that the penalty statute itself is not within the special competence of the Water Board. It clearly is. We know that because the Water Act on its face authorizes and in fact directs the Water Board to hold contested case hearings on alleged violations of the Act, and by corollary, the imposition of penalties appropriate to those violations. For all these reasons, it's inappropriate to engage the appellant's constitutional arguments at this stage of the legal proceedings. It's just a dollar short and a dime too late, or vice versa. Lastly, what I would say, and I know this hasn't been briefed by the parties, but I'm just going out there because I know the court has authority under Rule 13b to decide whether or not it has jurisdiction on an appeal. We believe the court's 5402 certification of this decision was appropriate. It disposed of an entire inseparable claim. It found that there was no just cause for delay, and it weighed all of the factors borrowed from federal jurisprudence in doing that. For those reasons, we feel that the 5402 certification was not improvidently granted. But we simply ask that the court affirm the trial court's decision in this case. Thank you.
Thank you, counsel. We'll hear from the appellant rebuttal.
Thank you very much. Your Honor, it's interesting to note that Chancellor Lyle looked at this matter, addressed the upfront civil penalties, yet on page 2 of her decision, reserved the right for the appellants to challenge both the proportionality and constitutionality of all remaining penalties in this matter. So obviously, it's kind of an interesting dichotomy. How did she reach the fact that you're time barred on one, but still yet hold open the ability of the appellants here and Mr. Byington, the individual, to move forward in challenging these down the road? I mean, it's interesting to try to reconcile those two to go hand in hand. Again, I think what the state says is that you can't go back and look at this order, yet that's what the chancellor has actually done here. She says you can go back and look. So obviously there is some basis in her argument to reopen and allow a challenge to this administrative order. We would ask that you reverse summary judgment and allow this to proceed on the issues of constitutionality in the Chancery Court. Thank you.
Excuse me, the court's thanks to counsel for both sides. We appreciate your briefs and your oral arguments today. I think we understand the issues and the positions of each of you. Mr. Hibbner, if you'll please recess court until our next scheduled case.
This honorable court is now in recess until 3 p.m.
Thank you, Your Honor.
Y'all have a good afternoon.